everyone. Welcome to the Caribbean Migration Consultations World Refugee Day webinar. We would first like to thank everyone who is joining us today from across the region, and thank you so much for your patience as we're getting started a little bit late. My name is Julia Hanby, Caribbean Relations Associate at UNHCR Regional Office, Washington. Our other panelists today are Amaria Belascri, Acting Head of the Caribbean Protection Unit at UNHCR Regional Office, Washington. And from the Cayman Islands, we are joined by Mr. Christopher Eakin, Chief Legal Affairs Officer of the Cayman Islands Ministry of Employment and Border Control, and two colleagues from the Customs and Border Control Service, Senior Deputy Director Bruce Smith and Assistant Director Joey Scott.
Good morning, everybody. This is Amaria, Julia's colleague talking from UNHCR in Washington, D.C. We're hoping that Christopher Eakin can fix the audio and join us a bit later with his two colleagues. Thank you.
We would also like to note that this webinar has been organized in close coordination and with the support of IOM's regional office in San Jose, Costa Rica. And Sofia Cortez from IOM Costa Rica is online providing much appreciated technical support. So please reach out to her if needed. As you may know, the CMC is a process initiated by Caribbean countries in 2016 with the support of UNHCR and IOM, and serves as a regional government-led dialogue on migration and refugee protection-related matters. Since its launch in 2016, several meetings and workshops have been held in the framework of the CMC regarding topics that have been identified as priorities by participating countries and territories. CMC webinars such as this are meant to serve as a platform for continuing to foster the exchange of information and discussion of priority issues within the region. This is the first webinar focused on refugee protection issues, and we would like to welcome you to make suggestions of other topics to be addressed through webinars in the future. In the first meetings of the CMC, participants identified the need for a common online platform for discussion and information sharing. And in response, IOM created the online platform CaribbeanMigration.org, which now serves CMC participants and other stakeholders. You will be able to find documents associated with this webinar in links that we will share with you in the chat box, so please keep an eye on the chat to receive the relevant links. If you have not already made an account on the portal, we encourage you to do so. We would also be happy to share resources with you via email following the webinar. Please note that our questions and answers session of the webinar will be written rather than using the audio function. Therefore, if you have a question or a comment, please use the chat box available on the right side of the screen. Should you have any difficulty in hearing, please also use the chat function, and Sophia is standing by to provide technical support to you.
Thanks, Sophia.
All right, so to provide an overview of today's webinar, my UNHCR colleague Amaria will begin with a brief introduction to UNHCR's Global Trends Report, which is released every year on World Refugee Day. Second, Mr. Christopher Eakin of the Cayman Islands will give a presentation on matters related to the asylum system and refugee protection in the Cayman Islands, accompanied by Mr. Bruce Smith and Mr. Joey Scott. And last, we will speak about some of the priorities related to refugee protection that have been identified by CMC participants and provide information on two different tools that UNHCR created at the request of Caribbean countries in order to support the development of national asylum systems. These two tools are the technical guidance for the development of refugee Caribbean and the checklist for a comprehensive asylum system. So without further ado, I will hand it over to Amaria.
Thank you, Julia. So just a reminder for all participants to keep their audio unmuted so that you can hear us properly, and then I will also unmute myself when I hand over to the colleagues from the Cayman Islands. So today is the 20th of June, and we are celebrating the World Refugee Day to pay tribute to the millions of refugees and people forcibly displaced around the world. And as every year, UNHCR released its Global Trends reports. So it's an annual statistical report that we publish on the occasion of World Refugee Day to analyze the global trends of forced displacement. And in that report, UNHCR does the monitoring and the tracking of the data of the people that are placed under its mandate. So you will find relevant data for various categories of persons of concerns. First, refugees and asylum seekers registered with the governments and with UNHCR. Also, we have displacement data of what we call IDPs, which are actually the largest category of people displaced, so internal displaced people. And also, you will find data on stateless populations, which are also placed under the mandate of UNHCR. So a quick reminder, please mute yourself. Thank you. Yeah, much better. So why do we do this report? Why do we publish it? So for sure, the purpose is a call for action to governments and to all partners involved in the protection of refugees and people forcibly displaced. And the fact that we are able to have those global trends and to have this global picture, let's say, helps inform the policy planning and the operational response of governments and partners involved in the humanitarian response. So what does the global report tell us this year? So these are the main figures. 70 million, actually more than 70 million people forcibly displaced around the world in 2018. That's double the level of about 20 years ago. And just to put it in perspective to the Caribbean region, it's more than the entire population of the Caribbean. It would represent more or less 7 times the population of one of its largest countries, like the Dominican Republic or Cuba or Haiti. You also have the breakdown of that 70 million figure. So the biggest share goes to the IDPs. So 41 million people are internally displaced within the boundaries of their own countries. Then 25 million, almost 26 million are refugees, and 3.5 million are asylum seekers in the process of having their claims assessed and their status as refugees determined. One of the main highlights of this year's report is that for the first time, Venezuelans feature as a major displacement crisis. So by the end of 2018 of last year, we had an estimated 3 million Venezuelans displaced across their borders. And this makes them the second international displacement situation worldwide after the Syria refugee crisis. And also what is very interesting to note is that in 2018, Venezuelans also featured as the first nationality claiming asylum. So 1 in 5 asylum applications submitted globally came from a Venezuelan last year. And it's very significant because, first of all, Venezuela is a country that is not at war, so that's really unprecedented that we have such a large amount of asylum applications submitted by a country like Venezuela. And it's also very significant because we know that many Venezuelans with international protection needs were also afforded alternative legal pathways, such as residency permits that also allow them to work. So here in this map, you see that in terms of asylum claims, Peru, for the first time, received a really large number of asylum applications from Venezuelans, 227,000, that's the figure in the blue box, over 227,000 asylum applications introduced by Venezuelans, followed then by Brazil, who received 81,000 such applications. And when you look at Colombia, Colombia has a population of over 1 million Venezuelans in the country. And as you know, in Colombia, they had access to a special temporary stay permit. So those figures are really overwhelming, and they highlight also the need for a coordinated response to tackle this issue and overcome the challenges. So now I pass on to Julia. Oh, really, sorry. So now I pass on to Christopher Eakin. I hope the audio has been fixed and that he can share his screen so that we can see his presentation of the Cayman Island asylum system. So Sophia, maybe you stopped the sharing of my own screen and you're helping with the sharing of Christopher's screen. So what I would propose is that we continue on from UNHCR. So with the CMC, let me share my screen again. That was it for the presentation of the Friends report. And if you have any questions, feel free to enter them in the chat box. And now we will continue with the CMC.
And hopefully we will have Cayman Islands join us shortly. And they're connected. Unfortunately, we just can't hear them. I'll go back to that at the end. So before we go into detail on the technical tools that have been developed in the framework of the CMC, we would just like to briefly highlight how the CMC has addressed matters related to refugee protection to date and the various topics that CMC participants have noted as priorities for moving forward. Several CMC meetings have taken place since 2016, during which participating countries and territories have exchanged information and identified common priorities. This includes the preparatory meeting in Belize in January 2016, in which refugee protection was identified as a key theme to be addressed in the CMC. Then at the first meeting of the CMC hosted by the government of Trinidad and Tobago in 2016, and the second meeting of the CMC Refugee Protection hosted by the government of the Bahamas in 2017, countries have further detailed their priorities through delivering presentations on a variety of topics and outlining some actions that could be taken collectively in the framework of the CMC. So we would like to note that at the first meeting in Trinidad and Tobago, participants created a list of priority issues in the region, which begins with the need to develop policy, legislation, and standard operating procedures at national and regional levels in order to promote a systematic approach to refugee protection. Countries have noted that the CMC provides a platform for carrying out capacity building initiatives and trainings, and it was agreed that countries would share their existing policies, legislation, procedures, manuals, etc., and would seek to exchange good practices and provide technical support to each other where possible through the CMC. And at the meeting in the Bahamas in 2017, participants delivered presentations and engaged in discussions on matters related to alternatives to immigration detention, the local integration of refugees and asylum seekers, and issues related to statelessness. The 2017 CMC meeting was also used as a platform for conducting an evaluation of progress made within the framework of the 2014 Brazil Declaration and Plan of Action. And participants have highlighted that the establishment of the CMC was in and of itself a great achievement, as this was a goal set forth within the Brazil Plan of Action, Chapter 5 on the Caribbean. And finally, it is important to note that this list of priorities is not exhaustive in any way, and it is anticipated that CMC priorities could be clearly documented and agreed upon within a regional plan of action specific to the CMC.
Thank you very much, Julia. May I continue on the CMC tools that UNHCR has developed, or is Christopher online with us and is he able to do the presentation of the Cayman Island asylum system? Yeah, I think I'll continue for the time being. So yeah, as Julia explained, within the framework of the CMC and at the request of the participating states, UNHCR developed two tools to support the countries with the development of asylum legislation. So first, it is what we call a technical guidance, or a example of a model law. And here you have the cover page, so you see how it looks like. Actually, it includes even the provisions that you would have in a given piece of legislation. So it's very detailed, it's very practical and hands-on, and it was circulated to all Caribbean countries, and we can also share with you after the webinar, so you can look at the various provisions in detail. But basically, it's a model that was drafted for the Caribbean, made specific to the region, but that can be further tailored to the specific context of each country. And among the key features, we're going to look at the definitions of refugees, asylum seekers, and stateless persons, the scope of this technical guidance. So it's refugee protection, but beyond refugee protection, it's also humanitarian protection at large. Then it also includes the procedures to determine the status of the refugees, the due process guarantees, and last but not least, the rights and responsibilities of asylum seekers and refugees. So the refugee definition comes in the section 2 of the technical guidance of that model law. And here you will see that in Article 3A, we have the 1951 Refugee Convention definition. So that's like the international one. And then we have the regional refugee definition in the following paragraph, which is drawn from the Cartagena Declaration. So you may be already all familiar with those definitions, but it doesn't harm to repeat them. So the 1951 refugee definition says that a refugee is any person who, owing to a well-founded fear of being persecuted for reasons of, and here we have the 5 grounds, the 5 protected grounds. So for reasons of race, religion, nationality, membership of a particular social group, and political opinion. That's the 5th one. So people who are then outside their country of nationality and who, owing to such fear, based on those 5 protected grounds, are unwilling or unable to avail themselves of the protection of their country. And the regional definition, which is an extended definition of the refugee, so it includes a situation where the person is facing a threat to his or her life, his or safety, liberty, due to a situation of generalized violence, foreign aggression. Here again we have 5 situations. So generalized violence is 1, foreign aggression 2nd, internal conflict, massive violations of human rights, or events that seriously disturb the public order. So in the model law that we propose to Caribbean countries, we also use the exclusion criteria from the Refugee Convention, so to exclude people that have committed crimes against peace, committed serious non-political crimes, or who have been guilty of acts contrary to the UN. So these are the three exclusion grounds that we have in the 1951 Convention that we use also in the model law for the Caribbean. So this is the difference between the refugee and asylum seekers, also that might be useful to some of you in the audience. So the difference is simply that the asylum seekers are undergoing the process of refugee status determination. So shall be considered to be an asylum seeker from the time that he or she has expressed such fear to the competent authorities, irrespective of whether he or she has been granted access to file an application for asylum. So we highlighted that part because we wanted to explain the fact that, yeah, the declaratory nature of the refugee recognition means that a person as soon as they flee their country and they meet the refugee definition criteria, they already meet the definition for being a refugee. But later on in the process, during the RSD procedure, they are determined as a refugee, and this recognition by UNHCR or by a given state has only a declaratory nature. It doesn't mean that as of that moment the person becomes a refugee. It only means that during the process the person was considered as an asylum seeker, but the person retroactively is recognized as a refugee from the moment the person fled the country and crossed the borders because of a fear of persecution. The technical guidance also provides a definition for the stateless persons, because we also have situations where a stateless person can also flee the country of their former habitual residence and then become a refugee as well. Now, in terms of the scope of that tool that we provided to the Caribbean countries, so we are explaining that the scope of any future refugee legislation in their countries could encompass refugee protection as such. So really people who fall under the 1951 Refugee Convention or under the Cartagena broader expanded definition, but also humanitarian protection at large. So that's protection granted by a state to non-nationals, to foreigners who do not qualify as refugees, but who have other compelling humanitarian needs. And this is what already happens in practice, that many countries, including in the Caribbean, have provisions in their law where it is the discretion of the state, of the authorities, to grant access to the territory. So that's what we mean by protection to people who are, fleeing a situation and they cannot go back to their countries because then they would face harm. So that already exists, but it is in the form of, a discretion by the immigration authorities, by the competent immigration authorities. Here in this draft asylum model law, we are proposing Article 9 and 10 that it is safeguarded in law, and that such humanitarian protection be afforded to people who a situation of harm in their country, and that's in compliance also with the Convention Against Torture, but also Article 10, and here it's really tailored also to the Caribbean context. We are mentioning that humanitarian visas or humanitarian admissions could be granted in response to natural disasters in neighboring countries. So when we have forced displacement in the context of natural disasters or climate change. And that would be actually very, very innovative if that could be incorporated into the positive law of one of the Caribbean countries. So then in terms of procedures for RSD, refugee status determination, you have an Article 17 that gives you that gives the flexibility to the competent authority to prepare like specific SOPs. So this is what we would recommend, that the countries has a specific standard operating procedures, and to establish also a specific asylum body. So it could be a refugee eligibility commission adjudicating on the claims, or it could be a refugee unit within the immigration department. So here we have the two scenarios, scenario 1 and scenario 2, that could be established within your governments, and UNHCR could provide advice to those review commissions. So act in an advisory capacity in those commissions. Then Section 4 of the model law that we prepared for the Caribbean is all about due process guarantees. So you have in Article 18 the right to appeal, the right to judicial review, due process, and also specific procedures for children. Rights of asylum seekers and refugees are also defined in that proposed legislation, with first and foremost the protection from refoulement, which is the absolutely bare minimum, but also the non-penalization of illegal entry or illegal stay in the country for asylum seekers and refugees. Of course, the non-penalization when they are victims of human trafficking or smuggling of migrants. Right to work is really crucial. So it's proposed there in Article 33, indeed, that refugees and asylum seekers should have, access to socio-economic rights. So it's also education, it's also access to healthcare and public services, just as any other, foreign in the country, so that they would be afforded the same treatment as foreigners that have the permanent residency. Now I can continue on the second tool. So that the second tool accompanies or complements the draft refugee law that I presented earlier. It's like a checklist, so it's made to be like more practical to check the boxes to make sure that we have gone through each of the steps. So it's meant to be as 4 steps that are there to follow a logical or chronological order for assessing the asylum claim. So first, we have to look at the asylum criteria. On what basis is protection being considered? Then the access to asylum. So how do we provide access to asylum? The procedures, the nitty-gritty of the procedures, and then the realization of rights to make sure that asylum seekers and refugees can be part of the society in which they live in, and that they can also contribute to those societies. So the first step is first to understand from a conceptual point of view on what basis we are considering providing protection to the asylum seeker who has presented a claim. So is it based on the internationally customary law? That's applicable to every country. So this box is always ticked. But then, of course, among the Caribbean countries, the majority of the governments have ratified either the 1951 Convention or its protocol. So this would also be the actual legal basis for providing protection. Sometimes, as we said, if the person doesn't fall, strictly speaking, into the definition of the 1951 Convention, we can also have protection against refoulement that is based on international customary law, or on the Convention against torture, so to make sure that the person would not be subjected to harm and irreparable harm back in their country. And the International Covenant on civil and political rights had also been ratified by a majority of countries in the Caribbean, so that would be also a basis by default, I would say, if the country is not a party to the Refugee Convention. And in some cases in this region, we also have the European Convention on Human Rights that would apply for the overseas territories of European states, the Netherlands and the UK. And of course, we also have to look at how those international commitments are translated into national laws, policies, and SOPs. So hopefully those three boxes can be ticked, and we even have a situation in a given country where we have detailed SOPs and we would know exactly how to handle this asylum claim that is being presented to us. So then in terms of access to asylum, what is important to also note is that most of the asylum claims are presented, at points of entry at air, sea, and land. So these are immigration officers that receive those claims and that have to screen them. So it's very important that they have the tools, the knowledge to make that initial screening, and most importantly, that there are referral mechanisms in place to refer the asylum claim to the competent body within the government or to UNHCR when the government has not ratified the 1951 convention. Training and capacity building to ensure access to asylum is also key, so not only to government but also to NGOs and other UN agencies, and public information at large to raise awareness on the right to seek asylum. So in terms of procedures, here is the list. It goes from the reception of that asylum claim. So once very often at the border or it could be elsewhere in the territory, the registration, documentation, data protection concerns is very important. Of course, the confidentiality of the procedure. The whole RSD process with the interview that is really at the heart of the process, the need for interpretation, that the fact that it has to be in writing and that the asylum seeker has to be notified also in writing of the decision, and the appeal and the judicial review. Then the fourth and last step in this sort of logical order for the asylum claim is the realization of rights for both asylum seekers and refugees. So non-refoulement, of course, is, as I said, the minimum, the bare minimum, not to return somebody to their country where they would face harm, and the access to, the full spectrum of human rights, including socio-economic rights. And as I said earlier, the position of UNHCR, or let's say the good practice, is that asylum seekers and refugees would receive the same treatment as permanent residents. So with this, I hope that we can have a concrete example of how a Caribbean country has developed its asylum system and its asylum legislation. So I think we received a couple of questions. Julia, can you maybe read the first one?
Sure. So the first question was asking for more information on the estimated implementation costs and operating costs of refugee status determination and the implementation of asylum legislation, given the economic position and human resource capacities of many of our countries in the region.
Okay, so I understand the concern here, and even internally as UNHCR, as a refugee agency that has been performing refugee status determination for almost 70 years now, I can say that it is something that is human resources heavy. So what I can say is that in terms of supporting the development of the legislation, UNHCR is there to support the government and provide technical advice. So we can, review draft legislation, provide comments, provide recommendation. That work is available and afforded to all the states. In terms of The operating cost of RSD, we understand that, yeah, it is, as I said, it relies heavily on human resources and staff. So that's why UNHCR is also recommending in some instances some accelerated procedures. So it depends on each situation, but in situations where we have a refugee movement, I mean a movement that is characterized as such as a refugee movement, we can provide advice on how to put together a accelerated procedure. It also applies the other way around when we have a situation, a group where actually UNHCR would advise against, the provision of the refugee status. So we would also recommend in both situations where it would be more likely it would be a grant or it would be a denial to employ accelerated procedures. That's for one. And also, the second thing that I wanted to mention is that to avoid that asylum systems are overwhelmed when we have a large influx, UNHCR also recommends the establishment of a group-based determination procedure, so to go faster and to be more cost-effective in general. And UNHCR is available, to provide a really individual advice to each state, given the situation that they are facing and the influxes that they are receiving. That's what I can say in terms of cost and budget constraints in general. What would be the way to go about that? I think we also had the first question regarding alternative to detentions. Maybe not question as such, but request for more information. So yes, Julia will follow up with those colleagues who ask for additional documentation on alternative to detention.
And I'll also just note as a reminder for everyone that this presentation and then the other resources that you're asking for, these CMC tools that Amaria just presented, the two tools, the technical guide and the checklist, they will all be located in the events section of CaribbeanMigration.org. We sent the link in the chat box to you, so please do visit that page later and we will upload all the relevant documents, and go ahead and create an account because some documents on this portal are private, so they're not available to the public. So please just go ahead and create an account and then you'll be able to access all of that information.
So you had the second question?
So we have another question I will read aloud that says, based on UN protocols, are all Venezuelans considered asylum seekers and or refugees, even though many of them are considered economic migrants? How are they categorized?
Okay, so here we would like to refer to an updated guidance note that UNHCR issued last month and that we circulated to the authorities in the Caribbean, I mean to all states actually worldwide, but here from UNHCR Washington we also disseminated to all our partners and counterparts in the Caribbean region. So according to that guidance note that was issued to states, UNHCR characterizes the situation of the Venezuela outflows as majoritarily a refugee movement. So the agreed terminology when we refer to the situation is to describe or to refer to the Venezuelans as refugees and migrants, and this is in line with the coordination platform that has been established in 2018 by UNHCR and IOM upon the request of the Secretary General. But given the pace of the movements and also the situation inside Venezuela, last month we issued that guidance note where UNHCR categorizes that a majority of Venezuelans are in need of international protection and asking that they are granted access to asylum procedures. So saying that Venezuelans under certain profiles, certain categories, are really more likely than not to fall under the 1951 refugee definition. and also that they would, a majority of Venezuelans would be considered refugees under the broader refugee definition of the Cartagena Declaration.
Okay, thank you, Amaria. We have a third question. This one is also related to the Venezuela situation. It asks, is exceptional leave to remain and return to the country of origin a durable solution for the Venezuela situation? Or are we expecting that Venezuelans neither desire or will be able to return after fleeing?
Okay, so in terms of durable solutions, there are three of them. First one is the return to the one's country of origin. So that's the voluntary return. Of course, it has to take place always on a voluntary basis in safety and dignity, and that's one of the three durable solutions. The other two are the local integration, where there are, local integration prospects. And the third one is resettlement to third countries. And UNHCR has agreements with some countries around the world that accept to have refugees resettled as part of, the responsibility sharing. So UNHCR really promotes those three durable solutions equally. And in terms of Venezuelans, so far, I mean, the crisis is still fresh, I want to say. I mean, we haven't seen any voluntary returns to Venezuela so far, or it has been very, very marginal, let's say. And if you ask me, are we expecting that Venezuelans neither desire or will be able to return after fleeing? I want to say no, we're not expecting that they won't have the desire, because in reality, based on UNHCR's experience, the voluntary return is the preferred solution of the majority of refugees. I mean, when they leave their country, they leave their home, they leave their lives behind, it's because they are forced to. But as soon as the conditions are better in their home country, that's the first thing that they have in mind, to go back. When will they be able to return? That's a different question. So that we cannot really answer. But I mean, by experience, we know that refugees do go back to their home country once the conditions, the stability is restored for their country, and then they can really achieve a durable solution back home.
Thank you, Amaria. So we have another question from Alana. She acknowledges the guidance note. And she asks if the definition and note was agreed upon by the UN General Assembly, i.e. UN member states.
The guidance note comes from UNHCR, so it's not a document that is issued by New York, by the General Assembly or whatever other organs of the UN. It's really UNHCR based on its expertise and on international refugee protection, and we do that for a myriad, of situations across the world. All the major refugee crises, we issue a guidance note to member states. So I would not say that it has been, agreed by the General Assembly, definitely not, or by the member states, but that's the advice that we give to governments. And thankfully, I mean, many countries and RSD, asylum authorities do follow those guidance notes issued by UNHCR in terms of who should be recognized as a refugee. In some situations, we also issue guidance notes.
Hello, testing.
The session. Hey,
is this Christopher Aiken?
Hey, apologies for the interruption.
That's okay. We're so happy that you're here.
Yes, yeah, I will just wrap up on that question, and or maybe there's another one on from Priyaki soon, and then we will hand over to you, Christopher. So yes, I was just saying that in some other countries also issue guidance notes on when a refugee situation has ceased, to meet all the criteria for the refugee situation. So yeah, it goes also both ways, and yeah, the asylum authorities of the governments across the world do reach out to UNHCR, you know, when they have questions. I mean, there is a dialogue, so it's not that our guidance notes are a document that is already negotiated and agreed by everybody, but there is a dialogue, and please feel free to reach out to us so that we can continue this discussion. Christopher, because we are a bit late, and then we will collect all the questions. So please continue with the chat box. We're very happy to see that you are active, and we will get back to you and continue the discussion after the presentation of the Cayman Islands. So we're now very eager and very curious to learn more about the asylum system in your country. Christopher, over to you.
Good morning. I wonder if anybody can hear me now.
Yes, we can all hear you, I think.
Okay, that's very good. Thank you very much. Thank you also to the UNHCR and the IOM for the invitation to contribute to this webinar on World Refugee Day. It's a great pleasure to connect again with colleagues from other governments in the region also. Let me begin by saying that much has changed with respect to migration management in the Cayman Islands since we last met at the CMC in Nassau in December 2017. Historically, the core functions of border control and migration management have fallen under the remit of the Department of Immigration. As part of a wide-ranging package of reforms, those responsibilities have now been separated. The Border Control or uniform branch of the Department of Immigration has merged with the Customs Department into a single border control agency called the Customs and Border Control Service. This agency is responsible for the protection of our borders, collection of import duties, and the management of travel and trade. Its vision is to strengthen the security and stability of the Cayman Islands through an intelligence-led risk management approach. The workforce management function of the Department of Immigration, and by that I mean matters relating to work permits, permanent residence, belongership, etc., has merged with the National Workforce Development Agency and the Department of Labour into a new entity called Workforce Opportunities Residency Cayman. This new agency reflects a redesigned approach to employment and workforce management that focuses on two core objectives. The first is full Caymanian employment. The agency will focus on delivering durable employment and opportunities for the advancement of Caymanians in the labour force through development programs, training, internships, apprenticeships, and partnerships with private sector businesses. The second objective is to ensure that our business sector has the manpower it needs to remain globally competitive. To this end, new, more efficient business processes are being introduced that facilitate quick turnarounds on work permit applications, but which also ensure that Caymanians with the required skills are not disenfranchised. Both new agencies fall under the Ministry of Employment and Border Control. I have now moved to this ministry to a new position as Chief Legal Affairs Officer. I will continue, however, to work closely with the Customs and Border Control Service on the legal and policy aspects of refugee protection and statelessness. Responsibility for matters relating to asylum and refugee protection now falls under the Customs and Border Control Service. New legislation passed in November 2018, which was brought into force in February 2019, re-established the statutory framework that was provided in immigration legislation for applying for asylum in the Cayman Islands. In essence, any person over the age of 18 years of age or an unaccompanied minor may apply for asylum if they are in the Cayman Islands. A person granted asylum may also apply for asylum for his dependent children under the age of 18 who are with him in the island. Decisions on asylum applications are now made by the Director of the Customs and Border Control Service. A person whose application for asylum is successful will be granted indefinite leave to remain in the Cayman Islands. Having been granted asylum, a refugee can work freely. If necessary, the government will continue to provide accommodation temporarily until such time as they find their feet. This is usually for 3 months initially, but could be extended if necessary. Responsibility for continued assistance may also switch at that time from the Customs and Border Control Department to the Department of Children and Family Services. Consideration is currently being given to providing access to English language courses and vocational training to refugees, and assistance will be provided in placing accompanying children in the school system. The new legislation passed in November 2018 also created a dedicated new appellate authority to deal solely with appeals against the refusal of asylum in the Cayman Islands. This new authority is called the Refugee Protection Appeals Tribunal. The goal of creating this new entity is to ensure that asylum appeals are processed quickly and adjudicated on by persons who have been trained specifically on the requirements of the Refugee Convention. The tribunal consists of a chairman, deputy chairman, and 3 other members, all of whom are appointed by cabinet. The chairman must be an attorney of at least 7 years called to the bar, and the deputy chairman must be an attorney of at least 5 years called to the bar. It was also recognized that persons sitting on the Refugee Protection Appeals Tribunal should have a solid understanding of the requirements of the Refugee Convention and their interpretation. In February of this year, 2 senior judges from the United Kingdom's first-tier Immigration Appeals Tribunal spent a week in Grand Cayman providing training to the new members of the Refugee Protection Appeals Tribunal and its Secretariat. They also provided training separately to the Customs and Border Control officers. The training focused primarily on the requirements of the Refugee Convention, but also included guidance on process. The judges also reviewed our legislative framework that underpins refugee protection and provided some suggestions as to how it could be improved. These are now being considered and may lead to future changes to legislation and procedure. Work is also underway to create a policy and procedure manual which establishes rules of procedure for the new tribunal and materials providing guidance on the process for filing asylum appeals. An appeal can be made to the Refugee Protection Appeals Tribunal within 14 days of the refusal notification on the ground that requiring the person to leave the island would be contrary to the Refugee Convention. An appellant cannot be required to leave the islands pending the outcome of an asylum application or appeal. The tribunal will then inform the director of CBC that an appeal has been received, and he must provide the tribunal with reasons for his decision within a reasonable period. The appellant then has 14 days in which to file detailed grounds of appeal. The parties to the appeal may appear before the tribunal in person or be represented. There is no fee for making an appeal. A second development in the past year that I can share with you relates to alternatives to detention. Some of you may recall that I gave a presentation on this at the last CMC, in which I explained the reasons why irregular migrants were generally detained as a matter of course. Since then, our approach has changed somewhat. In view of the length of time it was taking to process asylum applications and subsequent appeals, a decision was taken to allow persons who are awaiting a decision on an asylum application to be released into the community. The Customs and Border Control Department are currently creating the policies relating to this, but in essence, the process is as follows. All irregular migrants will be detained except for children and family units that include children. Those who apply for asylum will be detained for a period of 15 days for a preliminary assessment of their claim and to allow for background checks to be conducted. This period can be extended for a further 15 days if necessary for the same purposes. This period will also be used to arrange appropriate accommodation for when they are released into the community. But throughout this period of detention, the policy will ensure that those who are eligible for release will not be detained any longer than absolutely necessary. But the release from detention, even for those who have applied for asylum, will still be subject to a risk assessment to ensure that the release does not pose a risk to public safety. This will include background checks and health checks. When a person has been released into the community, they are also subject to conditions. These include a curfew. They can't be outside of their accommodation between 9 p.m. and 6 a.m. without special permission. In the past, this has been granted for Christmas and New Year. A condition of their release is also that they must comply with the laws of the island. With respect to accommodation, If accommodation has not yet been found, persons will be released into the care of local church groups. There is a long-standing history of assistance being given by Spanish churches in the Cayman Islands for families and children. Accommodation is usually in the form of apartments or rooms in apartments. There are also sometimes houses for larger groups. Civic centres will be used where accommodation can be found immediately. Persons released into the community will also be given vouchers from local supermarkets for food and supplies. There will also be continued access to legal befrienders, and this has been set up as part of the asylum process from the outset. Persons released are also free to obtain their own legal counsel if they wish, and funding for this can be transferred from family members through Western Union. There are no reporting requirements imposed on persons released into the community. During a period of release, there is also access to medical and dental services. So has it worked? For the most part, we are satisfied that this is working, as well as bringing us into compliance with international best practice. It has significantly reduced the financial burden on the government. It has also been recognized that persons in the asylum process are not necessarily more of a risk to public safety than any person landed as a tourist visitor. But there have been some challenges. For example, the logistical aspects of identifying and arranging accommodation is posing a burden on already stretched CBC resources. There are also problems where a released person breaks the law. This will also be a breach of their conditions of release. In serious cases, or where the person repeatedly fails to comply with the conditions attached to their release, they may be re-detained. This could be for an indefinite period based on the severity of the issue. But their detention will remain under periodic review. Looking ahead, I would like to say a few words about the next steps. I mentioned earlier that we're currently considering how our asylum procedure can be improved. One aspect that we have recognized is in relation to family reunification. Our immigration legislation currently does not make specific provision for matters relating to a family reunification, for example, where a refugee wants to be joined by his spouse and children. In practice, where a person has been granted asylum, we will allow their spouse to join them in the islands. Although there is no specific immigration category for this, they will simply be admitted as a visitor for periods of 6 months at a time. And if they wish to work, they may apply for a work permit. Certain work permit requirements may also be waived. For example, the requirement to be proficient in English. Officers involved in refugee management have indicated that additional training may be needed in relation to the circumstances where refugee status may be lost or revoked. For example, where the person may have re-availed themselves of the protection of their country of origin, or where a person granted refugee protection in the Cayman Islands takes up residence in another country for a significant length of time, but does not acquire the citizenship of that country. We may reach out in due course to the United Nations High Commissioner for Refugees for advice on those matters. I mentioned earlier that despite being in its infancy, the Customs and Border Control Department is already working on the creation of standard operating procedures for handling irregular migrants, the refugee status determination process, and the integration of refugees into the community. This will include setting target times for processing of asylum applications. For example, setting when an application for asylum would be considered to have been submitted in time. This relates to the requirement that a person seeking refugee protection should apply at the earliest possible occasion. We will also seek to set a target for the length of time between the receipt of the application and a preliminary interview with the person. Also, the length of time between the interview and the decision, depending on the particular circumstances of the application. We also want to ensure that a person will be given a time limit on the length of time that they have to produce information that they have in support of their claim. We also intend to set a target for when a decision will be communicated to an applicant. We also want to ensure that the requirements relating to the submission of an appeal are complied with fully so that there are no delays with that process. That brings me to the end of my presentation. I hope that you were able to actually hear and see what I've been talking about. I and my colleague here will be happy to take any questions that you may now have. Thank you very much.
Thank you so much, Christopher. That was an excellent presentation. I'm not sure if you can see the chat box on the right now, but I'll highlight, I see at least 2 questions that are directed to you. First is, what is the estimated costs to care for an asylum seeker or a refugee, such as accommodations, education, food, etc.? And that question is from Alana. And then there's a second question from Jose in Antigua and Barbuda about whether or not Cayman Islands has a stipulated limit refugee numbers given the economy of scale beyond which they cannot go, and then what would happen thereafter. So I'll hand that back to you.
Thank you, Julia, for the 2 questions. I'll answer the second one of those quickly, and my colleague from the CBC Assistant Director, Joe Scott, will tackle the first one. Quite simply, there is no limit or quota for persons seeking refugee protection in the Cayman Islands. It can be a difficult issue with respect to the financial burden that it costs, but we don't have any limitation on the number of persons that we would allow to apply for refugee protection. So now, if Joey would like to answer the first question concerning the cost of maintaining a person seeking asylum in the Cayman Islands.
Hi, good morning, everyone. In general, you have to understand in terms of costing that the Cayman Islands is an expensive place to live and be maintained. But on average, we're spending less than $1,500 per person US per month on migrants, and it can be significantly less. It just depends on, again, seasonal availability of accommodations and the number of persons that we have. You can compare it to bulk shopping at times, where you get a better deal the more that you buy.
Are you still there, Julia?
Yes, hello. Thank you so much for those answers. We have 2 other questions on the right side. First, what is the estimated number of migrants registered or not in the Cayman Islands? As well as what is the rate of acceptance of refugees and refusals? And then also a request for the presentation, and we can confirm that the presentations will be online on the platform. And how many asylum seekers are currently under your care, which is very similar to the other question. Please go ahead.
Yes, right now we have about 24 asylum seekers who are at various stages of the asylum process.
Thank you. And what about the rate of acceptance? I guess perhaps this is a decision on their claim.
Well, right now we're probably at less than 2%.
Okay.
I see that there's also a question here as how are the voucher systems and curfew taken by migrants? Does this produce destitution given the shortage of affordable housing?
No, on the contrary, it actually reduces the amount of destitution. We have internal guidelines as to the amount that we spend per person in terms of housing and in terms of other care. And what we try our best to do is to ensure that nobody is a destitute person and that everybody has basically access to an affordable standard of living.
Great. And then another question about RSD processing time. So how much time do you take to assess the claims and make a decision?
It depends on the complexity of the case. We've had claims that we've completed in under 24 hours, and we also have had claims that have taken us 6 months to come to a concise decision on.
Okay.
And these are speaking specifically towards initial decisions. That's not speaking towards any process of appeal or judicial review thereafter.
And there is also a question about the other statuses that you could afford to asylum seekers that have been denied. So the question from Priya is, are there derivative humanitarian statuses that people can be afforded?
Yes, there are a few others. We have the ability to grant persons basically what under local legislation we call exceptional leave to remain, which is different than the status of indefinite leave to remain. Indefinite leave to remain being a refugee or an asylee. With the exceptional leave to remain, those are circumstances where persons who are refused asylum because they don't necessarily qualify under the statutes for that, but there are other compelling reasons why they shouldn't be returned to their country.
Okay, excellent. And the conditions of detention, also Priya is asking, I believe you mentioned the alternatives to detention, but if you want to develop a little bit more on those HCDs.
The conditions that we have for our current detention center, you could equate it to a low security prison system. And again, it's not a prison, but there are restrictions on being able to come in and out of the property.
Okay. Margaret,
was there any specific was there specific information that Priya wanted to know that I might be able to expand upon?
Priya, do you want to type a bit more if you have any other specific questions about the detention facilities?
But I think the main principle is that yes, they are not detained like among convicted criminals, and that you said it's a low security facility, and most importantly that there are also provisions for an alternative to detention, so that they would report, etc. But yeah, after a certain period of time, that they could leave and be released and have an opportunity to live with the community, which is the most important.
Yes, that is all correct.
Great.
Okay.
Policy and procedure. I see a question from Alana here. Are there any policy and procedure documents you can share? As I mentioned in the presentation, those are currently being worked on, and it is a task that the Customs and Border Control Department are focusing on specifically right now. And at some point in the future, when they have been formulated and written formally, I imagine that we will be happy to share those with others in the region. I've seen as a question that have you seen a rise in asylum seekers since the Venezuelan situation has started?
Well, we've never had, prior to this year, any asylum seekers from Venezuela. This year so far, we've had 3 asylum seekers, 2 of which withdrew. All of these persons were persons who were resident in the Cayman Islands at the time, and they have not been able to leave basically because of travel documents being expired.
So we had received a question from Priya earlier, and please go ahead, Julia, read it.
Does this mean that interim humanitarian status that is renewable is best aligned to return to the origin, I guess the country of origin, as a durable solution? So some form of temporary protection that could be renewable. I think the question is if that would be a suitable response for Venezuelans.
Yes, definitely. I think we can confirm that the fact that Colombia and Peru and Ecuador and other countries have afforded like amnesty procedures, residency permit, and work permits aside the asylum channel is already a very good protection response, and that it is very suitable to the situation as long as refugees are protected from forced return and that they can access the basic rights in the country where they temporarily live in. I mean, that's perfectly aligned with what UNHCR would recommend. So, Priya.
Yes, in terms of
Yes.
in terms of the Venezuelans, likely for the Cayman Islands at least, we would be looking at extending most likely exceptional leave to any person who would apply for it, given the circumstances in Venezuela at this time. I'm not sure what others in the region are doing with those. I know that they have a lot higher numbers than we do.
Yeah, no, many other countries are doing the same, and that's very good. I don't know if other participants from various countries would want to make an intervention or not, but yeah, basically, so far, I mean, when we look at the situation in the continent, it's in the platform we have that statistic, so you can also check the regional coordination platform that has been established by UNHCR and IOM, and you have access to the stats. So it's R4V, we call it R4V response for Venezuelans. So it's easy to memorize. And there we have millions of Venezuelans who have been granted exceptional leave to remain, as you say, in the form of residency permits in the country. And that's really an enormous, show of solidarity within the region towards the Venezuelans, something that I think we have not seen in other displacement situations across the world. So that's really good.
I see Priya has a question that she's asked for advice for countries who consider whether there's any difference in the treatment of refugees when they make their claim at a port versus making an inland claim. And I can say from the Cayman Islands perspective, the way we process those persons is the same. Obviously, the same guidelines, the same principles apply. The only difference is for persons usually who land at a port, they usually have proper documentation that we've seen in our experience, whereas other persons may not necessarily have proper documentation. Now, the proper documentation makes the difference for us between whether you are initially detained or not. If you do not have your proper documentation, we make our background checks and you could be detained for 30 days and potentially longer. And generally, persons who have proper documentation are not detained at all. We don't detain people for making an asylum application, obviously.
Mm-hmm.
We only detain people who do not necessarily qualify for landing. So I just wanted to be clear about that, and I hope that answers the question for Priya.
Yeah, thank you very much for this. That's very helpful. There was a question about the skill set. So obviously it would depend on each hosting country when they have data on the Venezuelan asylum seekers or beyond Venezuelans, any asylum seekers and refugees within their territory. They would know the age, the profiles, their educational background. But what I can say for the Venezuelans in general is that, in many countries where we have had access to some data through some, monitoring and profiling collection exercise that we have conducted, is that they are highly educated and really very, very eager to work. So then the Spanish language can I mean, it's easy for them to work and integrate in the continent in countries where they speak the same Spanish language. In others, where the use of English is the dominant language, yeah, this is the main challenge or obstacle that they face. But they have represented so far quite a big asset in terms of skill set and additional competencies and skills that they can bring into the hosting country.
Yes, integration is something that the CBC is having a look at here, and the nature of the assistance that might be provided to persons who have been granted refugee protection in the Cayman Islands. It is recognized that not every person will be able to speak English well enough in order to be able to obtain employment in every occupation. But in that regard, consideration is being given to providing access to English language classes to allow greater integration. But a person granted refugee protection is allowed to work in any industry or occupation that they may be qualified to work in.
Mm-hmm. Yeah, a question on
Here,
when the CI legislation was passed. Yeah.
Yes, CI legislation was just passed, if I'm not mistaken, a few months ago, about in February, has basically incorporated most, if not all, of the central features of the CMCs. Yes, the legislation that provides the framework for matters relating to asylum was passed in the Legislative Assembly in November 2018, but came into effect in February 2019. Mm-hmm. The framework for asylum matters effectively duplicated what existed previously in immigration legislation at the time. And in essence, it is very similar in terms of process as the CMC's technical legal guidelines. And of course, now it has been expanded to incorporate the separate independent refugee protection appeals tribunal, which is a fast track now to appeals for those who have been denied asylum in the Cayman Islands. But in general terms, yes, it is similar to the CMC's technical model.
Very good. So I don't know if there are more questions, but because it's been over an hour and 20 minutes, I was thinking of maybe wrapping up the conversation, but I'm really glad that we really entered into this discussion, and also remotely with all the participants across the Caribbean. So maybe a last question from BVI. Are asylum seekers that arrive at ports given permission to enter until their case is decided on? Yeah, I think this is the case. If they present a claim as an asylum seeker, they are admitted into the country. But please, Christopher or colleagues from the Cayman Islands, if you could better describe this procedure.
Yes, that is correct. Persons who are asylum seekers are not required to leave the Cayman Islands unless and until they have gone through the complete legal gauntlet, and that can take it all the way up to the Court of Appeals.
Indeed. So, yes, other questions can be maybe answered offline. I want to make sure that you also have our contact information. Maybe I should have included them in the PowerPoint presentation, but we can see with the help of Sophia from IOM how we can also reach out to all the participants who joined this webinar today. And yeah, maybe we don't have all your email addresses, so I hope we can. Feel free to share now in the chat box your contact information if that's easier, because I'm not sure it's automatically recorded when you join the Blue Jeans platform of IOM. So really, thanks a lot. This is our Caribbean Protection Unit email, the generic one that you can use, USAWACAB@UNHCR.org. So we can definitely continue this conversation offline. And I really want to give a warm thanks to Christopher and the two colleagues from the Cayman Islands. It was very informative, and I'm really glad to see that you have a very elaborated and sophisticated system in your country. And again, UNHCR stands ready and available to support any other Caribbean state in the development of asylum legislation. So please don't hesitate to reach out to me, to Julia, and yeah, we will be in touch with you. Thank you.
Thank you so very much, everyone. Thank you to the Cayman Islands, and thank you to IOM for all the technical support and collaboration as well.